Morning, ladies and gentlemen. It's 11 a.m. East Coast time. Go Kansas City Chiefs. Wearing our masks today. I apologize. There'll be a few technical changes this time. I'm in Oklahoma City. We're moving offices today, and everything is moved, even the electronics, except my iPad. So we're working from that. Welcome to our umpteenth episode. This is, I think, day 72 of my coronavirus beard. We've been sheltering in place for 72 days now. Our firm actually is not scheduled now to go back to July 1st. We're just lucky that we can operate from home and don't have to worry about it. Today, our presentation is from Greg Keogh. Greg, are you there?
Hi, Steve. Thanks for having me today. It's a pleasure.
Good. Glad you got to join us. Greg's from Dublin, Ireland. He came over to play soccer and never left. I think he's got about a 6-month-old child now, right, Greg?
That's correct. 6 months, 22nd of this month.
Ah, great. Greg graduated top 15% of his law school, and he was on the Indian Law Journal. He's the assistant managing editor. So he's a pretty sharp guy, and he's going to come back later to talk with us about actually Casualty, which deals with a lot of the litigation in this country, typical Casualty. First, let's go to the Holden Institute and see what's going on out in the world. There we are. Current state of COVID litigation, May 27th. Mitch McConnell says that the new coronavirus aid package won't pass without liability reform. There are 1,100 coronavirus-related cases already filed. Many of those will be casualty. The casualty will actually come on stronger as this progresses. A lot of this so far is lost profits, D&O litigation, but that will change. Unfortunately, the U.S. Remains the worst affected country in the world in the number of COVID-19 related cases and deaths. There are others trying to catch us, like Brazil, but so far we hold the dubious spot, which of course directly bears on the casualty litigation that will occur down the road. Got some bad news from the CDC. Says the current antibody testing is wrong up to 50% of the time. So what is that antibody testing worth? Nothing. You cannot use it to open your businesses. People who rely on it to open their business, you're going to see the casualty claims coming in for that. So we hope down the road we get some better antibody testing. The public health experts say that there's still no state that has met the criteria for a safe reopening yet. That's concerning. I'm always most concerned about the double bounce and what that'll do to our economy, and really what it'll do to our morale and our psyche. Contact tracers. We'll talk about that more here in a little bit. The CDC says that 100,000 are needed. We currently have just a little over 2,000, and they are STD contact tracers. And so we will need to get to the others, and I'm going to discuss this part of it more later, because the contact tracing is going to be very important in your casualty work when those type of cases, COVID direct cases, come in. The last point there I have is actually the one that concerns me most going forward. 33% of the country is showing signs of depression and the onerous nature of the COVID situation. That is the next wave that will not so much deal with casualty, but there will be some signs of it. But that's not a good portent for what's going to happen down the road in this country. let's take a look at what's going on out there, and let's go up to Lake of the Ozarks and see how they're doing over Memorial Day. Most of you probably heard about it, but up at Lake of the Ozarks, this is what was going on. You don't see a mask. There's no social distancing. People who they've never met before hanging out very tightly. This, fortunately, was not the norm, but it still is going to cause problems for us going forward as far as preventing this thing as it moves, so we can try to eradicate it. Greg, let's bring you back on, and if you will start your presentation, we'll kind of do some co-presenting. I may have some things to throw in here before I get down to my section during the question and answer, but Greg, please take off and fill us in.
Thanks again, Steve. Again, it's a pleasure being here. Before I, jump into the presentation today regarding the COVID-19 and the impacts on the casualty insurance industry, there's one thing Steve raised, and I want to just touch on that. As far as the increase in depression and anxiety, for anybody that is feeling any type of symptoms, it's very important, especially for men, because in this day and age, men have this kind of taboo where they shouldn't talk about this stuff. But if anybody is feeling any type of depression, anxiety, they feel overwhelmed, please reach out to someone you love and discuss that with them. So with that being said, jumping into the presentation, before I get going, there was a couple of factors that I wanted to touch on briefly. These factors are very important and should be considered moving forward for the insurance industry. So 3 different factors. The first being, of course, it's obvious that millions of people have been staying home and driving less. Whether that be from working remotely or, unfortunately, many people have been laid off from their jobs. So that, of course, is going to have a huge impact on the insurance industry moving forward over the next few months, if not years. Second factor would be, of course, many businesses have been forced to either close, whether it be permanently or temporarily, and many other businesses have been forced to significantly curtail their activities. So, of course, a good example of that would be restaurants where up until a point they were not allowed to have customers come in and dine in, and they were forced to just use carry-out services. The third factor would be, of course, the high unemployment rates and the declines in consumption within the business activities. This can be expected to last at least the next few months. It's going to take a long time for the American economy to get back to where it needs to be. So with them 3 factors in mind, they should definitely be considered in any industry, but most importantly in the insurance industry moving forward. So taking these factors into consideration, I think it's obvious that there's going to be an increase in lawsuits for motor vehicle accidents and collisions. There's also going to be a decrease in premise-related general liability claims for most, if not all, non-essential businesses, such as restaurants, bars, hotels. Of course, if there's no customers, there's going to be a decrease in litigation and lawsuits. However, on the other hand, I think we can expect there to be an increase in premise-related general liability claims for most essential businesses, such as pharmacies, supermarkets, that kind of business.
Yes, I feel like most of the industry is with wishful thinking, hoping that the casualty doesn't blossom with everything else with COVID. But I think if we're not seeing that how massive this is going to be, this litigation that in some way tangentially relates to COVID, there's going to be a lot there. I'm expecting there won't be actually a reduction in litigation over time. It's just that the auto may go down, some of the business losses will go down, but the COVID GL, CGL will go up, in my opinion.
Yeah, certainly agree, Steve. So with all of that in mind, what are some of the general liability claims that we can expect to see either during or even after the coronavirus crisis? So I think the most likely scenario for a potential general liability claim being brought either during or after the COVID-19 crisis would be based upon a business owner's alleged negligence for failing to protect customers or invitees from being exposed to the virus. So a good example would be a business owner who would place customers in a situation where that customer is exposed to the disease in a heightened sense. Basically, if that business owner would, say, for example, fail to screen employees for symptoms related to the coronavirus, asking employers simple questions such as whether the employee has been out of the country or visited any countries that have high rates of infection at this time. Another good example would be if an employer fails to allow an employee to take a day off, if that employee is complaining that he or she is feeling sick, and if they don't turn up for work, they ultimately could lose their job. Of course, if a customer or an invitee to that business contracts an illness through circumstances largely within the control of the business, such as in these examples, the customer may attempt to hold the business owner liable or responsible for any damages that are incurred. I think it's also important to note that general liability claims can also stem from a potential workers' compensation claim. So based upon facts or circumstances that could give rise to a workers' compensation claim for an employee, a family member who ultimately contracts the virus from that employee could also potentially bring a claim against that business owner if that business owner exposed the employee to the virus from alleged failure to use reasonable care to protect that employee and ultimately their families. So I think there's many avenues that can be brought against employers or business owners for general liability claims. Of course, there are numerous real-life examples of general liability claims that have been brought as a result of the COVID-19 virus and the crisis that has came with it. I think two of the most highly publicized examples of alleged business negligence during the coronavirus health crisis are the lawsuits that have been brought against the Princess Cruise Lines and against Walmart. So with regard to the Princess Cruise Lines, I'm sure many of you all know, Princess first received a lot of criticism in the early days of the pandemic when it continued sailing within the continent of Asia, despite the mounting health concerns. So this has actually given rise to at least 7 notable lawsuits pending against Princess Cruise Lines. Many of the passengers alleged that the company failed to implement proper screening procedures and took a lackadaisical approach to customer safety. So of course, just looking at these lawsuits, taking the first one that was actually filed, this was a case that was filed in California, and the plaintiffs in that lawsuit claimed that the company proceeded with a voyage on February 21st, 2020, despite knowing that 2 of the passengers who had previously disembarked the ship from a prior voyage had actually been showing COVID-19 symptoms. So of course, this is pretty alarming. If these facts are established and do come out as being true, the Princess Cruise Lines could find themselves in a spot of trouble. So the plaintiffs in that lawsuit also claimed that the company failed to inform the 62 passengers and crew members who were previously on board with the passengers who experienced these symptoms that they were also being exposed to these potential symptoms and the threat of contracting the virus. So the plaintiffs basically claim that the company breached its duty of care because it had knowledge of the prior passenger symptoms, and they failed to inform and protect the plaintiffs from exposure to the risk of immediate physical injury, which caused the plaintiffs to incur emotional distress and trauma from fear of contracting the virus. So Of course, this actually, based upon this language in the petition, it seems like that the plaintiffs may have not actually have contracted the virus, but they're more incurred emotional distress and trauma from the fear of contracting the virus. So it's going to be interesting to see how this one pans out over the next couple of weeks, if not months. So the plaintiffs in the other Princess Cruise Line lawsuits also claimed that the company continued the cruise day after day without significant change to the ship's protocols. And they also claimed that the passengers were also encouraged to leave the ship and visit port cities in Vietnam, Hong Kong, and Japan, despite the company's knowledge that there may be exposure to the coronavirus. So going on to the second lawsuit, a second highly publicized example would be a wrongful death claim brought against Walmart. So specifically, this wrongful death claim was brought in Illinois state courts as opposed to the workers' compensation system in Illinois, based upon negligence of Walmart due to the death of a COVID-19 infected employee. So that one is interesting in the sense that it was brought in state court as opposed to workers' compensation court. According to the plaintiff's complaints, Walmart failed to exercise reasonable care to keep its store in a safe and healthy environment, and in particular to protect employees, customers, and other individuals within the store from contracting COVID-19 when Walmart knew or should have known that the individuals at the store were at a very high risk of infection due to the high rate of traffic that comes in and out of the store and the ongoing pandemic. The plaintiffs also claim that the store management failed to properly clean and sterilize the premise, provide adequate protection and protective gear to employees, and to enforce social distancing recommendations by the CDC.
Greg, and you kind of hit upon it. The first thing a casualty adjuster is going to think at this point is, are we even messing with this workers' comp claim? Just so everybody understands, this was not filed as a workers' comp claim. The plaintiffs didn't want the limitations of the workers' comp claim. Most states have special provisions within their workers' comp that if it's an intentional act or so egregious that it could be interpreted as an intentional act, that they can move outside the workers' comp arena and into the civil side, into the casualty side. You're going to see this happening a lot. I believe the courts will shut it down fairly quickly. Courts don't like to get outside the workers' comp arena because it just makes for a mess. But that's how they're attacking it at this point.
Yes, thank you, Steve. I believe that is exactly correct. While it does not explicitly state it on the face of the complaint, it does appear that the employee's estate is attempting to avoid the exclusivity bar for workers' compensation claims. There is an allegation within the complaint that says that Walmart acted willfully, wantonly, and recklessly by failing to implement proper health and safety measures. So it does indicate that the estate is attempting to avoid the workers' compensation by using the intentional wrong or intentional tort exception. That would be correct.
Greg?
Yes, sir.
One other thing while we're on that point, and I know we have a few underwriters on the line. First off, I'd recommend to underwriters that, when they're writing a big account, like a Walmart, that type of an account, they find out what the guidelines are that are being followed and how closely that company is to following the CDC guidelines, which are not very solid right now, but they still give guidelines. If the companies follow a set of guidelines like CDC, then the odds of it getting outside of the comp arena are low, very low. If, however, the company has, they don't follow the guidelines, or even worse, they profess to follow the guidelines and do not, then you run the danger of it getting outside of the comp system into the casualty system. So be very careful when writing these accounts that they are following them closely. And I'll talk about it a little bit later, but that's one of the first things as a casualty adjuster I would want to do is find out what the guidelines were at the company where this alleged event germinated.
That's exactly correct, Steve. You know, the CDC and other government agencies, they of course produce these guidelines for a reason. And while they would not be binding law in the sense that a business does not necessarily have to follow these guidelines, if the business does not follow these guidelines, they're certainly setting themselves up for a potential lawsuit and potential tort liability. So just back to the Walmart claim, based upon them facts, the estate, the employee's estate, alleges that as a proximate and direct cause of these facts, the decedent employee was infected by COVID-19 and ultimately died due to complications of COVID-19. So while this particular claim and this particular set of facts gave rise to a lawsuit that was brought by an employee, we can clearly see how an employee's family member, if they were ultimately exposed to the virus due to contact with that employee, and that can be traced back to Walmart or some other business owner, we can see how there can be a negligence or even a wrongful death claim brought against that business owner by a family member of an employee. So again, while you know, employees are generally limited to the workers' compensation system, there certainly are certain facts and circumstances that can give rise to lawsuits within a state or district courts. So with all of this in mind, let's take a look at what an insured can do to defend against COVID-19 related negligence or general liability claims. So just kind of back to basic torts, in order to successfully prevail on a negligence claim, a plaintiff must of course show that a defendant owed that plaintiff a duty of care, that defendant breached that duty of care, and as a result, the plaintiff's damages were proximately caused by that breach of duty. So looking at these three elements, I think the third one stands out for a few reasons. I think the most important reason would be that a plaintiff will most likely have the most difficulty attempting to establish the causation elements. So looking at causation, in order to successfully defend against a COVID-19 claim, defendants such as Princess Cruise Lines, Walmart, or you know your mom and pop store that may be exposed to potential liability must focus their defense heavily on the aspect of proximate cause. So of course, proximate cause has two components, cause and fact and foreseeability. So in this fact scenario, I think defendants will have a better chance at succeeding in their defenses by arguing that a plaintiff could not prove by a preponderance of the evidence that the alleged negligence was a substantial factor in bringing about that harm, and absent that negligence, the harm would not have occurred.
Greg is out of our Oklahoma City office, and one of our young gun associates is very good at what he does. He and I have a slight disagreement on this as to the quality of proof. I've had 200 plus jury trials, actually defended about 70 cases for Walmart alone in my early career. Let's remember, casualty folks, our jury is made up of employees who work at these companies. And jury psychology teaches us what jurors worry about is not so much the plaintiff, but about how they would want to be treated at their workplace if the proper measures were done and they were followed. If the matter gets to a jury, and in most of your state courts, especially rural counties, I think it will get to juries. You have to be careful in not under-evaluating how good your evidence is based on the mental processes of your jury. It's just kind of what I call when the rubber meets the road, what will really happen.
So I don't disagree with you there, Steve. You know, of course, juries are unpredictable, and looking at defendants, especially corporate defendants, it does make that a little bit more difficult in trying to defend a type of claim such as this. However, I do think that it is highly important in defending these type of claims that defendants focus at least some of their attention on defending the proximate cause element of the claim. I think defendants should argue that the plaintiff cannot make out a proximate cause showing because the array of community exposures to the virus creates a reasonable doubt. I think there's going to be very limited circumstances in which a plaintiff who's been exposed to the coronavirus can trace exactly where they received this exposure or where they were infected by the virus. I think, you know, pinpointing a specific instance or events which caused the persons to contract the virus will prove not just challenging, but in a lot of cases, it will prove to be next to impossible. After all, you know, not every person becomes infected. While they may actually be infected, they may be asymptomatic. They don't show any symptoms. And even if they do, it may take a long period of time before they do start showing them symptoms. It may also remain unclear as to how or when that plaintiff or the claimant was exposed. So, of course, I think it's going to be difficult to show that an insured negligently failed to keep its property free from recognized hazards that are causing or likely to cause serious physical harm or even death. Again, back to what Steve had touched on just a few minutes ago about how it's very important that businesses and insureds should practice and try to obey the CDC guidelines, OSHA guidelines for opening back up their businesses. I think if they're taking these steps and doing all that they can in order to protect their employees, their customers, their invitees, I think that will, of course, help in the long run. Okay, so just following the causation stream of thought, I think with regard to defending COVID-19 general liability claims, an insured or a defendant should also focus on the requirement that a plaintiff prove causation using expert testimony. I think Steve and I may also be on a little bit of a disagreement on this one. Of course, with the coronavirus, there's very little case law, if not none right now at the moment, as far as what exactly plaintiffs need to establish in order to prevail on them claims. But if we look at prior health crises such as the Ebola or other infectious diseases, I think we can kind of extrapolate and find some case law that would establish that a plaintiff must use expert testimony in order to establish causation. So the common understanding of the layperson based upon this case law would be that a layperson cannot testify as far as causation for a virus such as the coronavirus or the Ebola virus. So, for example, in the Texas Health Resources v. FAM matter, the Texas Court of Appeals in Dallas concluded that the likelihood of transmitting the Ebola virus, assuming different policies and the use of different protective equipment, is beyond the layperson's common knowledge or common understanding, and an expert witness was therefore required to testify regarding the same. So I think especially for cases brought in Texas or in Dallas, I think this prior case law could, of course, help to establish that requirement for a plaintiff moving forward.
Greg, that's an excellent point, because right now we're all shooting in the dark a little bit of what the law will be in relation to COVID. We have the Ebola to connect to, we have the bird flu to connect to. We really don't know how it's going to turn out. I practice in Texas. let me tell you how it's going to turn out down in Nueces County, Corpus Christi area, and down in the valley. If the plaintiff says, I was at work, or I was visiting the Walmart, I was visiting my grocer, and the employee was sneezing, and I told the manager and nothing about it, and then lo and behold, I became sick. I'm not sure that it's really going to take expert testimony to get that to the jury. In fact, in the Nueces and in the Valley, it probably won't. There are other things that I want to talk about later that will help bolster that so it doesn't get to the jury. But the expert issue is very important, but I don't think it's going to necessarily carry the day in a lot of our small counties.
Well, even if that is correct, you know, I certainly think that expert testimony defending against these particular claims would be something that we would recommend for our insureds and our defendants in these particular cases. So using case law and, you know, assuming that I'm correct and Steve is wrong, that the big ask, by the way, I think courts may make a similar finding that the likelihood of transmitting COVID-19 through contact tracing is beyond a layperson's common understanding, and therefore a plaintiff will be required to prove causation using expert testimony. So accordingly, absent expert testimony that can arguably establish causation, defendants will likely prevail in negligence claims by plaintiffs. Again, Steve may disagree with me.
No, actually, I agree with you, and I didn't want to leave people with the impression that we don't need to get the experts lined up. Texas is its unique setup is we've got the Valley. You're not going to get much fair treatment there. But the big equalizer in Texas is the Texas Supreme Court. So you've got to have your ducks lined up. Sure, you want to win at the first phase. But if you line your ducks up right with the expert testimony and it's solid and they don't have good expert testimony on their side, that the Texas Supreme Court has shown they're more than willing in these type of cases to then throw them out. So the expert testimony is absolutely critical in preparing and settling. If you don't get the experts and try to settle a case down in Nueces County without an expert, you know, you're dead in the water.
So just kind of going on the expert testimony. So I think even if a plaintiff does retain an expert witness to testify as to causation, I think it's pretty obvious that the insured should then focus their defense on the ability to attack the witness's credibility or the testimony. So without kind of laboring this point, this is pretty straightforward and clear. And the defendants, of course, can attempt to establish that the expert is simply not qualified to testify on the subject, whether it be that expert lacks any experience in that particular field, or the witness simply lacks the education and the qualifications. The defendant should also attempt to establish that the expert's theories and techniques are flawed for some reason, or that the expert witness is biased in some way, whether it be that this particular expert testifies for only plaintiffs and, you know, testifies for a large sum of money every single time. I think there are, of course, points that should be looked into when, you know, deposing that expert or cross-examining that expert. So the final area I wanted to briefly touch upon before moving into some questions and some of the additional information that Steve wanted to discuss is the argument for immunity from claims relating to the transmission or infection of COVID-19. So as Steve briefly touched on in the beginning, we've seen Mitch McConnell, of course, has basically said that a coronavirus package will not be passed without some type of immunity or qualified immunity for businesses. So I'm sure many of you, if not all of you, all know that legislators and governors across the country are also considering providing businesses with some type of immunity, whether it be full immunity against employer-related negligence claims, or qualified immunity for certain businesses, or qualified immunity in the sense that the businesses must make certain requirements in order to qualify for that immunity. So just some of the pros and cons. Of course, while immunity from negligence claims would instill a greater sense of security and confidence in employers and would help to restart the economy, a full immunity solution may unjustly frustrate the path to legal recourse available to plaintiffs with legitimate claims. I think building off of that, immunity may also disincentivize employers from taking rigorous steps to protect against employees or customers or invitees from contracting the virus on their business. Of course, if there's going to be a full immunity without any requirements, that may also have some very negative effects for the country and for the economy. So I think to calm concerns that businesses may not follow the precautionary measures if granted complete immunity, I think an alternative compromise would be in the form of qualified immunity. So of course, qualified immunity may apply to businesses which meet specific precautionary standards. And that of course could be following the CDC's guidelines, OSHA guidelines, and any state virus control guidelines. So of course, that would mean that a business must take, certain precautionary measures in order to protect employees, customers, invitees, then particular classes of people from exposure before obtaining any type of immunity.
Are you done with the slides there, Greg?
Yes, sir. I'll take that down.
I wanted to go back to talking about qualified immunity for a little bit. Everybody on here is going to think I'm kind of a wet blanket because I kind of seem to, instead of glasses half full, I'm saying it's half empty. That's not true. I'm a glasses half full sort of guy, but I have tried several hundred cases. I've seen judges, how they handle it. I've seen plaintiff attorneys, how they get around it. Qualified immunity, there's a full immunity for a subsequent remedial measure. Now, how many adjusters out there have had a court sustain the subsequent remedial measure? I've had it sustained in part. I cannot think of an instance where some piece of a subsequent remedial measure didn't come in or affect the case. What does that mean to the qualified immunity? The qualified immunity, let's say the qualified immunity is if you follow the CDC's guidelines, then you have qualified immunity. Well, you know what the fight will be over, folks? It'll be over, did you follow them? Under the circumstances of your store, of your shop, were you following them to such a degree that it would have prevented this if done properly? That's going to be the attack. They'll, of course, the plaintiff bar will fight the qualified immunity anyway, but even if it comes in, that is not going to be the big deal that stops this litigation. This litigation is going to go forward. Greg, let me talk, get back on here. There's a few questions here. One of the questions was to me about contact tracing. And I want to get kind of your view on this too. First off, folks, contact tracing is nothing but detective work. The defense comes down to, it wasn't me. My shop didn't cause it. Yes, you came in here to get your hair done, but you didn't get it here. The only way to really try to put an end to that is through contact tracing. Remember, CDC says we need 100,000 contact tracers, and we've got 2,200 STD tracers. What we're going to have to do, folks, from the adjusting perspective and the law firm perspective, we're going to have to get in quickly and do our own contact tracing, because it's very critical. Where did it come from? yes, we may have it in our beauty salon, but did the person who's now claiming they got it from us, did they bring it in? Or was it already there? Then if the proof is it's already there, can we trace it back to someone who was like a typhoid Mary? They carried it, but they didn't present any symptoms. Only through rigid and swift contact tracing are we going to find that out. Our paralegals are trained in the contact tracing. We're actually trying to get on with to get our training through CDC also, but of course they don't want to be CDC tracers, but we would like to have that training. But yes, our paralegals are trained to do this, but right now it's still fraught with danger because there's no way to know where you've crossed the line or not. Contact tracing. First thing you think of is, well, HIPAA. What goes on with HIPAA? Mm-hmm. Well, obviously you can't disclose to the person you're contacting that has been, let's use the beauty shop again, it's been the beauty shop that, hey, on that day, the person that sat immediately to your right turned up with COVID. No, we can't do that. So it's kind of a nebulous call of, yes, you've been determined to be been in the vicinity of someone with it. Explanation, but you can't really tell them a lot. The asymptomatic carrier is going to be real trouble for everybody, but the contact tracing is how we narrow that down. If whenever you get a COVID allegation come in, get on it immediately. Get your law firm, get their tracers out and doing it. We also have our own contacts with professional tracers if we need to go above that level initially, but don't hesitate to jump in and get that done fully, because that's where your defense is at. I would also, and I mentioned earlier, I wouldn't mind underwriting, checking shops. Of course, they won't be able to do that with the little shops. When they got the bigger institutions like a Walmart, like a CVS, others, do they have good set guidelines that they are following? Greg, you ready for some questions?
Fire away, Steve.
All right. Okay, first question. With regard to immunity, have we seen any governments actually enact laws or regulations to protect the insureds?
Yes, we have actually. We've seen quite a lot of particular executive orders, even some state laws, and the federal government has even taken some steps to protect businesses and potential defendants against liability. So, of course, many states, including New York, Missouri, the governors of them states issued executive orders granting some type of immunity to healthcare providers during the coronavirus crisis. Actually, as a matter of fact, both New York and New Jersey have actually taken this one step further and have enacted state statutes to provide the same. So, of course, in New York, Governor Cuomo did issue an executive order, and sometime thereafter, the state legislature actually put that into law. So basically, the legislator enacted this particular act. It extends immunity to almost all healthcare facilities and healthcare professionals. It's obviously intended to promote the public health, safety, and welfare of all New York citizens and healthcare professionals. And the law applies from, I believe it was sometime in early March until the end of the state of emergency. The federal government, as I mentioned, also took some steps in order to create some types of qualified immunity for certain persons. So one of the steps they took is Congress recently enacted what's known as the Families First Coronavirus Response Act. So prior to the passage of this act, the Public Health Service Act provided immunity to manufacturers of FDA approved masks only. So in businesses, a lot of other businesses use a lot of different masks that were not actually FDA approved. There was only a small percentage of masks that were FDA approved. However, Congress, of course, passed this Families First Act, and it expanded immunity previously afforded to manufacturers of only FDA-approved masks to manufacturers of masks and other protective gear that has been approved by the National Institute for Occupational Safety and Health. So that just creates a broader immunity for more manufacturers and producers of these health and safety equipment and masks, respiratory equipment and the like. I think Congress also recently enacted the Public Readiness and Emergency Preparedness Act. So basically that empowered the Department of Health and Human Services to issue a declaration that would immunize certain entities and individuals from liabilities that could stem from the use of countermeasures to combat the disease. So what that would be any particular vaccinations, viruses, medications that would be used to combat the disease. So Congress did pass a limited immunity for them particular entities or individuals.
Greg, as you might have guessed, is one of our 7 lawyers that's on the COVID team. We now have over 1,000 hours in research and writing on all things COVID. And so Greg's like many of our lawyers, is a fountain of knowledge. Greg, there's another question here, which I think we've answered. If the lawsuit brought against Walmart was based upon the death of an employee, why was it not brought in workers' compensation court? I believe we answered that because it gets outside when you claim that they're grossly negligent or intentional in their acts. But if the questioner needs more information than that, give Greg or I a call or send us an email and we'll flesh that out some more. The one last one, and it's, I'm not going to be, it's getting down to the end here. I'm not going to be able to deal with it completely. How do we evaluate a COVID claim? That's a seminar unto itself. Basically, you get started with like what we were saying. You get your contact tracing done, so you preserve what information is there to be had. Don't rely on the government that their contact tracers are going to take care of it. It probably won't happen. The other is not to underestimate the public's opinion of what's going on with COVID. This is the biggest stamp on our country since probably World War II, as far as a pervasive effect over the country. The final outcome and what juries will do is yet to be known. But remember, our jurors are primarily employees. They're the people that primarily would potentially be, filing the litigation. So they think like employees as jurors. And then they will put a little heavier burden or a lot heavier burden, we don't know yet, on the company to have done a better job of protecting them in the process. Do not underestimate claims from family members. Let's say you have an employee at company X, they get sick at company X, they go home, their wife gets it and dies, or their parents gets it and dies. We're back, Greg dealt with foreseeability. I think most judges will say that's foreseeable. And if you were negligent in letting the employee get sick, then it's foreseeable that that employee is going to go home and sicken others and cause potential death. If a jury finds in their mind that that was done flagrantly, without due attention to the safety, not the profits, the safety of the employees, then there will be some H to pay in that circumstance. I invite the individual that sent in that question to call me and discuss further. actually what will happen a lot when cases come in, and we do this a lot, adjusters will call us and ask us for advice. No file open for us. They just want some guidance of what we've seen, because we see a lot across the country. What we've seen, what we'd recommend, how we would attack it, etc. That's without a file open, without a bill being paid. More than happy to do curbside consults for adjusters who are trying to weed their way through this COVID hell is all I can describe it as. Greg, I want to thank you for your presentation today and all your hard work on the COVID group. Keep after it, and we may have you back later in the summer, depending on how the litigation starts to evolve, and see if we have some more information we can give to our folks as to how they're being handled and how they're being defended. Ladies and gentlemen, we will check out now and we'll go back to work, but do be safe out there. As I say, as we say in Texas, be safe and keep your head down. And let's all keep moving through this. All right, folks. Thank you. Bye-bye.
Thank you, Steve.